without a critique and counter.
You have any big overviews?
No. Now, for testing their picks often only applies in a world in which we defend such interpretations limiting for the way they have was not opinion to make any link or make that any new application from one and now with Foucault, they consider our DNA impacted on this because it indicates that the extermination population because it becomes an actual objective of politics. You've also considered alternative assaults in the entirety of the criticism. She says that she and sort of Foucault evidence indicates the law is law functions only as a cover for complex social relations that actually account for phenomena that are described in the what I see there. What I see operates on a presupposition that we can actually enact meaningful change through the law and ignores the subtle phenomena that actually give rise to those phenomena. Also, our Foucault mediums you're not answering the one C indicates that actually the court is specifically as no political emancipation because the way that the court structures relations between litigants, plaintiffs, etc. simply reinscribes a particular hierarchy of social relations that serve as a matrix for interactions. The future also grants evidence indicates affirming legal rights and gives people a full sense of security because it mass disciplinary operations of power that operate in subtle forms outside the rights and still maintain control. She says we open this subjectivity. You talk about subjectivity, yes, that is fine, but you do not make a substantive method argument. Principal and link arguments here, they all apply to this argument, and the government constitutes subjectivity. The general reason goes two ways. Winter 96, which gets does not understand productive powers, the literal and productive power, and presently consort individuals with us, and how we ask our wiser people and dominate. Let us ask things we love on doing subjugation, those are subject of rights, government designated in a random sector, regularly council, the multiple scheme force, which are addressed subject, and a constitutional solution, and Senator Dean Evans indicates the empowerment is an operational progressive relations. It gives an example of government policies related to the poor, where supposed to be humanitarian policies directed to the poor, where it simply means more effectively incorporating them into states of capitalist nominations, uses permanent reputation for system for putting out evidence against an analyzing power, or trying to enact meaningful change from the standpoint of institutions fails because power in social relations are always prior to institutions and only give institutions their meaning, but institutions don't actually confer meaning back onto social relations, so they can't actually make a meaningful impact on anything. And consider for idioms that the court can't do anything meaningful. I'll explain this evidence. And even if you direct your defense or subjectivity to say the court is still a bad way to do it, she just plans prerequisites of personal autonomy. This simply puts it on the horse. It pursues a blanket and enact meaningful change. We're simply doing better analysis on this question. That's a Foucault 80 and ransom 97. And put it in the evidence. Now the next we see card. I think this is the first 9-page card. We impact her institutional action. I've already explained our Foucault and evidence. There is no reason that this evidence does not put the court before the horse for the same reason that your evidence other evidence such because it presumes that we can actually enact meaningful change from institutions or concluding the outstanding comparative evidence on this question indicates that power precedes institutions and institutions can't confer anything meaningful back onto relations. Now the Foucault explained Hartman evidence. First, this is simply an aspect of Foucault thoughts. You should still examine the link level. This isn't universal Foucault. Okay, it's our argument must critique is methodological. Our argument must defend the method of enacting social change via the laws of good practice. That is the disposition of all of our link arguments and naming that benefit operating in institutions is collective imagination. Don't read into that. Government telling me question in terms of specific problems with population management or decide certain procedure to war having a master retention problems or detailed elaborate contribution forms of elements. Proposition like way measuring this constant order collecting problems or continuous resolutions of also makes no limit to the ways in which management population can be a problem test government and tally that. But in order for policies here also be able to compel to continue search into an absolute way tracking them the importance of which you can actually find themselves and mesh the also is removing the assumption fashion ways in which governments can have a problem test like governments for the unintended consequences seriously were problematic cases in terms of policy theory. She says sometimes our policy you probably should have read evidence or made any kind of warrant for this random play, and Dean disagrees with you. That evidence indicates that my political authority over the authority to administer ideal populations is the political logic behind universal nuclear warfare in the absolute extermination of anything that is not ideal. What's considered alternative, which means we solve that effectively. What else am I going to count on? Counterbalance also links to tribe evidence of capacity of the treatment choice cycle for critical reproductive rights, and it builds momentum for future legal consensus. There is which means there's a solvency evidence over the plan. They have conceded this tribe evidence. Also, relies on and says, that solves all your court key evidence that articulates a critical distinction that you don't engage even if the Sheehan evidence is true. And court decisions that vital importance are West evidence indicates that the counterbalance legal action reshapes the constitutional framework on which judges base their decisions, which means not only does it but result in the Sheehan evidence of knowledge all your quirky options, but it also solves all your rollback arguments because it fundamentally reshapes the constitutional enterprise, on which courts would base their own rules. She says that the case key-based machine evidence. I've already explained this. I've already explained this. It's in the West evidence, and the only comparative evidence was what she had. Says the court's got to act on West evidence indicates that we can incite the court to act in a progressive manner via the capital plan. And she can forget her gather evidence. However, the capital plan is key to However, the capital plan is key to shadow legal realism that constrains our imagination, prevents us from articulating more popular constitution framework. Therefore, the questions some might have thought about the series we had never encountered from the history of perhaps we should have framed us with multiple and understanding and shape of reason by defending our sense of things we want to invite in the world's popular constitutionalists might have no sense to perceive the constitution and possibilities might believe that the constitution is direct relevant to the actual substance of constitutional law and popular constitutional laws are bad even those implied to accept the supremacy of general interpretation to go outside itself and product of a larger set of process of generating legal meaning and popular constitutional interpretations are critical to spring a paradigm shift the best performance rights and democracy West and I progressive constitutionally could try if the progressive interpretation of the constitution conservative or whatever will entertain the progressive interpretation of controversial leading such court if basically the agenda from the implicit grand second and third will rights to constitutions over the interpretations of waiting classes responsible as conservative or not and could allow the word progressive congress the easier greater progressive congress might progressive system really likely to having one answer the constitution progressive progressive constitutions were British but during democratic court they will serve progressive and confidently give constitutional answers of the constitution by actualizing to get intent on some progressive purpose and keep his rival part in 99 within democratic rule law and even social dispute aside the other laws also have to necessary words of violence when I think the kind of 21st century we have our fingertips right away those impacts uniquely outweigh the case because we can only have autonomy in a system of government which is open, democratic, and accountable, which means that accountability is a prerequisite to supplicate a case and all the 4 key warrants in the game evidence would be answered by the accountable because we result in the same legal consent a same or broader legal consensus on the question of reproductive rights to plan and cheat such permutation for settling all our distance court action and accountability and they can't access or progressive points because court resistance is key to public mobilization which the United States Congress signals need for constitutional proposition and the people's constitutional signals that are the management of the ordinance the signal purpose and so presently like over the state of law corporation court resistance is key to legislate the opportunity for conservative people will reconsider and in contrast to important congressional interpretations that secretary of constitutional law West and one short of the constitution should be a constitution rather than the course of progressive constitution should be critical constitutional progressive to create more progressive guidance and reasonable and constitution third court and incremental substitutional proposals but the constitution void occurs when the face of constitutional will this conservative court change paths and she says we don't assume the creation of a new interpretation group this with the legal evidence by the rollback first you need to prove a propensity that the court will roll back none of this evidence indicates that the court is protected from whether the court will actually roll back only said the court would have the legal authority to roll back and the Supreme Court will roll back the constitutional plan precludes rollback from the 1960s in which Congress is very concerned that the Constitution and Court may be likely to show deference to congressional interpretation in the country of private person and court can show willingness to defer to congressional interpretation determined in 92 being the only interpret the Constitution is not the same as being the only interpreter court is another expects other branches of the government the federal government to interpret the Constitution the interpretation of powers and branches to be great respect to those including importance of the case courts will show a great deal of deference to congressional interpretations and Congress can functionally roll back and forward to court decisions to be rollback is actually dissent to the case for two game terms to do this part of the lay on criminal limitations Supreme Court to rely on the major issues of public policy comes like Congress responsibility include translating the main and public reserve rights and what resources will be used how many where a single this will get overturn several Supreme Court decisions they say conditionality bad however this would apply in a world in which we are conditioned to get 2 worlds two worlds and they don't contradict with each other which means we can strategically grant offense on one and screw you 2 worlds is there's no reason 2 worlds is abusive especially when we can't use steps goes reverse and you actually haven't made some of the organism to they say they in the one area getting answers to the 2 and our Congress shifts culture at the courts meaning even if the kind of plan gets rolled back we embed the values of the case in the society 797 change the legislation more like a agenda culture shift and change the corporate legislation therefore proper laws will change people last point for the culture embrace the social norms of legislation we see people out like deep and African the public that means thing that's considered about parts we do about certain questions and the rule comes about and the idea is important what it says.
Before she asks you a question, you're interested in conditionality where we won't go for the quo and I don't get either one of your arguments?
No. First, it's not conditional. We have 2 worlds, one of which is a method argument.
Okay, not conditional.
We have 2 worlds. One of them is a method argument that doesn't link any more to the other.
I understand.
Next argument is that we don't get to defend the status quo.
Okay, I think I know.
Alright, so why do you still get these shift arguments in a world in which the counterplan, we win rollback and the counterplan doesn't happen? Like in a hypothetical world where the
rollback and counterplan not happen are not the same thing. In the world in which the counterplan is rolled back, Congress does the counterplan, court says and decides they're going to roll it back. Still, the fact that legislation is passed embeds those values in culture. That's
if it's passed and like a week later the Supreme Court strikes it down, how does it embed anything in society?
Well, our evidence indicates that the process by which you engage in lawmaking...
Does it assume a world in which this legislation lasts for like 24 hours?
I mean, it doesn't make that explicit distinction.
Okay, let's talk about the rollback debate. I'm confused how we can win this debate. You read evidence saying Congress has a lot of constitutional power. We read evidence saying the Freedom of Consent Act would be perceived by the Supreme Court as a violation of Commerce Clause 14th Amendment and 10th Amendment.
First, Rob, you need to prove that the Supreme Court would roll it back.
I mean, we have evidence saying they perceive it as unconstitutional.
Yeah, that's Congress
can.
Like it says they will.
You're reading an argument about how Congress can win a fight by like stripping the appellate jurisdiction or something like that.
Perot, yeah.
Yeah. Is your argument that they would do that for the counterplan?
If the court rolled it, or the argument works two ways.
Yeah.
Supreme Court rolls back the counterplan.
Sure. Congress
starts chipping away at the power. Supreme Court passes the plan. Any risk of opposition from Congress means they cut down on the actual.
So your argument is that Congress would strip the court from appellate jurisdiction and freedom of choice.
On what?
Your argument is that after the counterplan, Congress would strip the court from appellate jurisdiction with the freedom of choice act.
In a world in which the court actually tries to roll it back, that probably happens, yeah. Probably in a linger.
Sure.
Right. I'm confused why the counterplan leads to the Sheehan evidence. The Sheehan evidence says that justices need to explicitly tell the public that they are doubting themselves and overruling their own decisions in order for legal rights.
Sheehan evidence kind of says that. It says that the Supreme Court is the linchpin of like social media.
No, that's okay. Well, I understand you think this is a court's key because like court's important. But okay, let's talk about the critique. If we're not able to redefine and manipulate subjectivity, and presumably your alternative does not get rid of law, the executive, the Supreme Court, how does it solve if we can't change that subjectivity?
Anything. I made this explicit. You never answered this argument that, or you never engage critique at the level of methodology. We don't fiat criticism. It's very negative because your method is bad.
How, if the state imposes subjectivity and your argument is subjectivity is not a two-way street, how do you do anything ever?
Well, you contest the alternative, which says we have to adopt criticism.